You will have a chance to respond to her arguments. Please do not interrupt.
Welcome to Courtroom Secrets.
Defendant versus Lamatier, 25000747.
Good afternoon, Your Honor. Violet Oscar on behalf of the plaintiff, Midland Credit Management.
Timothy Antoine,
Right.
by special appearance.
Do I have Timothy Lamatier here?
Yes, here by special appearance.
All right, today's date and time set for motion.
That's correct.
Okay, so this is Mr. Lamatier's motion. Go ahead.
Yes, I'm seeking the judgment based on the review of my documents.
I have a motion to dismiss. So I just need to know why it is that you believe that the case should be dismissed.
Defendant was never served and lack of subject matter jurisdiction.
All right, Ms. Osco?
Yes, plaintiff is relying on the documents that were filed with this court. First of all, in our response, Exhibit A, we provided proof of service via alternate service that was filed with the court, is under an oath by the process server, and according to the tracking number with the certified mail that was provided to the defendant, it was unclaimed. If you look at the sticker, it states unclaimed. And also it's handwritten on there, notified 7/31/25. And upon further review of this particular tracking number, it does state that the individual picked up at post office, according to that particular tracking number. And also may I add that this was filed with the court on June 2nd of 2025. It is the document that is titled Verification of Process Server. Our process server did verify with the postmaster a request for change of address or box holder, and it is
Objection, Your Honor.
off. May I please continue? It is
Hold on one
checked
second.
off.
Hold on, Ms. Osco. You were interrupted there. So I didn't catch that. Hold on, sir. You will have a chance to respond to her arguments. Please do not interrupt. Go ahead, Ms. Osco.
Thank you. And also may I add that with the document that was filed with the court back on June 2nd of 2025, the request for change of address or box holder, it was checked off by the process, by the postmaster, no change of address order on file. That is all.
All right, now, sir, your turn. Go ahead.
Yeah, Your Honor, I object to everything in entirety and two reasons why. The first reason why is that I haven't received any competent evidence that this person has been deputized to represent the interests of the plaintiff, and I demand that this unknown person place a bond under oath for the record. The second reason is that I have not lived at that address since 2022, and I have not received any evidence of anything that this person is speaking of, and I object to all of it as hearsay. I have submitted evidence to the court that I have received a move-out letter from the Woodlands Gardens Apartments, which is the address in which the plaintiff has filed the suit or whatever the complaint is, that it matches that address to Woodlands Gardens. That is their property. I would also like to say that I have not received, to specify my standing, I have not received any copy of the complaint, and I have not received service. I have also not lived within the jurisdiction of this court, which is why I asked for dismissal by subject matter jurisdiction.
Any other comments, arguments, Ms. Osco?
No, basically that is the information, that is the address we had on file and we believe to be the defendant's address at the time we filed the lawsuit.
Just so I understand, it appears that this motion was triggered by the notification related to the default. There's been no judgment entered in this case at all, correct, Ms. Osco? At this point, there was a request, but there's been no judgment entered.
I see that there was a judgment entered, and that was entered on February 3rd, 2026.
Your Honor, may I speak?
I see. Hold on. I see it. Mr. Lematier, did you get their response to your motion?
I have not received any response to my motion.
It was e-filed on June 25th.
Okay. Any final arguments, sir?
I just would like to add that I don't know this person. I received initial correspondence from this person in October of 2025. From the address that I received mail from, and I've included a copy of that notice with my filing. And since that date, I have not received any correspondence concerning this matter. They claim to have served me at an address that I do not live at or receive mail from. Is entirely inaccurate, and anything to the contrary is hearsay. I have not been presented with any evidence to the contrary.
Wait, I'm confused. So you had some contact with them in October before the default was entered, and didn't file an answer or respond?
No, I have not. I've never received a complaint to file an answer or response. I have no idea what the complaint is. I've never been served. What I want to let you know is that on May 20th, I received a copy of the default request entry and judgment, and it was
Well, what happened in October?
I received a collections opportunity, a notice, I offered a contract with this person that I've never contracted with before. It was a demand for money. I've included a copy of that, I believe, with my motion. Your Honor, do you understand how I've come to understand about this case here?
What's that, sir?
I said, do you understand how I've come to be aware of this case?
That's what I'm trying to ask you, sir. Those are the questions that I'm asking.
Yeah, I received at my proper address a copy of the judgment on May 20th of this year. And that's it. Which would be evidence that the plaintiff was aware of my proper address, and they never communicated with me. They never attempted to serve me or give me a copy of the plaintiff at that address. So I had no knowledge that this case even existed until May 20th of 2026. And it prejudices my right to defend against any claim against me. I also do not live within the jurisdiction of the court.
I apologize, Ms. Osco. I'm trying to put the pieces together, where the efforts were made to serve him.
Your Honor, may I add that we did finally obtain defendant's P.O. Box address, and that is how he was served with the entered default judgment. I believe
Objection,
that's
Your
what
Honor.
the defendant is referring to.
Objection, Your Honor.
What is your objection for?
That's hearsay, sir. My first communication with them was on October of 2025, and that communication contained the address, which they ended up sending me the default. So they knew what my address was.
So, sir, that's why I give you another chance to speak. The objection would be if there was something that was legally improper for her to put on the record. That's her argument, then you'll get a chance to do the same. And if last time I checked, every single time that you have something to say, she doesn't interrupt you. So just hang on a second, all right? I always give people a chance to respond. So Ms. Osko, please, again, before you were interrupted, I just wanted to understand. So, so there was, at some point in time, the obtaining of this PO box.
Yes, that is correct. We filed with this court on April 27th of this year, proof of service that we did mail the default judgment to the defendant at the PO box.
And is that just so I understand, is that the first correspondence through this entire time that has ever gone to that PO box?
Yes.
All right, so Mr. Lematier, it's my understanding, because you had indicated that you didn't get a copy of their response. I just wanted to make sure you knew that it went into they e-filed it, and so that might explain things. I don't know for sure that whether or not it was sent to you, it was made available in the through e-file. But long story short, a motion to dismiss is not appropriate at this stage. Now, if you had provided this court a motion to set aside a default, I certainly would take a look at that. But there's not a basis. There's not a basis for me to dismiss their case. I can. What I could do again. I can't give you advice, sir. I'm denying your motion to dismiss, but I'm telling both parties that if he presents to me a motion to set aside the default, I would consider that and hear any arguments related to that. And then if I reinstated the case, any motions related to venue and all that kind of stuff, I would certainly take a look at that, sir. But a motion to dismiss their case, I don't have a basis for that right now. But I'm indicating, so Ms. Osko, so you can be prepared as well. If he does decide to do a motion to set aside this default judgment, I can certainly take a look at that, and we can go from there.
Yes, sir. It's stated within the relief. It states it asks that you set aside the default judgment.
But your motion was titled "Motion to Dismiss."
Yes, it asks for you to set aside the judgment and dismiss the action, sir. Okay,
so I actually don't have an issue with giving Mr. Lematier a chance to, now that there was a proper address, he did respond relatively quickly to that. I do note as well, Ms. Osko, that there was periods of time where this case actually got to the point where it was going to be dismissed for failure of progress on the file. So we have Mr. Lematier here. We can get to the bottom of these issues. So the motion to dismiss is denied. The relief that's requested to set aside, I'll grant that. Defendant is to file an answer within 21 days. The court will set a pretrial. If the defendant fails to file an answer, the court will reinstate the default judgment.
I'm sorry, sir. Are you saying you're going to give me a chance to review the complaint?
I'm giving you a chance to, yes, you should get a copy of the complaint. Ms. Osko, you have his address now. Send him a copy of the complaint. The PO box is a good address, correct?
Yes, I submitted the correct address.
Okay, so you'll get a copy of the complaint, and then within 21 days of receipt of that, you need to file an answer. If you don't file an answer, then the court will move forward for a default. You seem as if you are serious about challenging this case. If you are, then I would expect an answer within 21 days. The answer I would expect would contain all the other challenges that you brought up today as reasons why that there shouldn't be a case against you on behalf of Midland Credit. So I'm giving you a chance here, sir, to litigate your case. And then Ms. Osko, we'll see what he has that is serious, and then you can talk to your client about, whether ultimately he's brought up a venue challenge here, whether we can look at all those things.
Okay. Will the court be entering such order, or shall the plaintiff submit one for a court's entry?
If you could submit one, I would appreciate it.
Okay, will do.
So, sir, you should look for the, does seem to be some issue with understanding e-filing. So if you send him a copy of the complaint again, and then that way he can answer it, Ms. Osco.
Yes.
All right, sir, do you understand what the court's looking for from you?
The court is expecting me to receive a copy of the complaint and to file an answer within 21 days.
Yeah, once you, 21 days of the receipt. So don't worry if it takes a week to get to you, you haven't lost 7 days. Once you receive it, you got 21 days. Then we'll set up for a pretrial, and then we can get to the business of resolving this case.
I understand.
All right, thank you both.
Thank you.
All right, thanks.